I am going to introduce my panel. You should pay much more attention to them than me during the course of our presentation today. So on my immediate left is Jennifer Breen, who probably doesn't need much of an introduction to an ABA audience. She's a partner at Morgan, Lewis & Bockius, and she's vice chair of the Administrative Practice Committee of the ABA. Sitting to her left is John McDougall, who has been with the IRS Chief Counsel's Office in Richmond, Virginia for 42 years. And I want to congratulate John on his long public service. He'll be starting a well-deserved retirement quite soon. He's currently a special trial attorney in SBSE, and for the past 16 years, he's been principal counsel to the service's Offshore Compliance Initiative. Prior to that, for about 15 years, he was a special AUSA in the Eastern District of Virginia, and he tried a substantial number of criminal tax cases. To his left is Rosemary Sereti. Rosemary is the Deputy Commissioner of LB&I, and she's previously had other executive positions in the service, including Industry Director for the financial services industry headquartered in New York City, Director of the International Individual Compliance, Director of Field Operations in Manhattan for LMSB, and the Deputy Director for Pre-Filing and Technical Guidance. And finally, last but not least, is Maggie Harris, who is currently the Director of International Operations for the Office of Appeals. Prior to joining Appeals, Maggie served as an attorney advisor and assistant to the branch chief in Branch 5 in the Office of Associate Chief Counsel International. So I'm very appreciative for my illustrious panel today. We have a pretty extensive agenda, as you can see, and I'm going to turn it over to Rosemary to kick us off with changes to the LB&I exam process.
Thank you. Is this on? I think it's on now.
Yeah.
Okay. So maybe if we can go to the next slide. So thank you for, I'm happy to be here today. This first slide, I'm not going to spend a lot of time. We've been talking about our reorganization for a while. In February of 17, it'll be a year. I think there is still a lot to do for us. This was a good stretch for us to get where we want to be, and it's going to take some time. We are organized the way we want to, but there are a number of things that we continue to work on. And I think if I go to the next slide, I'll talk about some things here. So for those of you in the room who thought today would be the day that the IRS and LB&I would announce what the campaigns are, that is not going to happen. I think if it was going to, it would have happened this morning with the Division Commissioner, Doug O'Donnell. Not to say that it won't be me who does it, but between Doug and I, we will be announcing campaigns in the near future. What I do want to talk a little bit is as to why it's taking us so long, what you might expect when they come out, and we can go from there. So first of all, we've had a significant number of suggestions from our employees, several hundred suggestions. And so it's taking us a while to work through those and figure out which ones we want to put forward. We envision this putting forward a set of campaigns. What we want to demonstrate is that our issues cross our filing population, the ones we want to put forward first, whether it's a large multinational, a closely held mid-market, an individual who is doing business, has investments abroad, or an individual who might be doing business here in the US, or a corporation. So we want to show that we have a variety of issues, and we also want to demonstrate that we are going to use various treatment streams for those particular compliance issues. It's not that easy to do, and so what we don't want to come out with is, here are the 7, 8 campaigns, and we're going to audit every single taxpayer. We are trying to get away from the traditional examination approach on our issues. So that is, we've got them kind of in a place where we've identified probably which ones will come out, and I don't see it as being that much longer. And when we do come out, we'll talk about why we're in that space and what we expect to achieve in those campaigns. We also recognize that when we put some of these out, there'll be an opportunity to maybe adjust based upon some feedback. Some of them might even have feedback incorporated into the campaign itself, and so without giving too much away, it's coming soon, just not today. So I don't know if anybody here has a question or...
Yeah, I had a question for you, and I know that none have officially been announced yet, but I know that there has been reports that transfer pricing has a campaign that's focused on issues related to inbound distributors, that maybe this was going to be rolled out in 5 states with a thought that it was going to be expanding to 5 more by the end of the fiscal year, and then perhaps there were some other campaigns in the works with basket options and captive insurance, and so I don't know if those were, or if those are part of this, or if that was maybe a different program, or if there's, I guess, any information about that you guys could speak on.
Yeah, so those 3 issues were announced, I'm not sure, I'm losing track of time, 4 or 5 months ago. They were not part of the official announcement that would go out. A lot of that work has already kind of been out there. We've been examining, that's somewhat in the examination treatment stream, shall we say. Whether or not they're part of the initial set that goes out there, I do think we will continue to stay in that space. If you look at what we're doing in some of those areas, those are what you might expect from a campaign. But the one thing I would say about that is most of those are an examination approach, and that's not all that we're going to put forward. So I really don't, I think that's why we're waiting also, is that we have other issues, other compliance matters that we want to demonstrate, that we're not just going to do an examination. So, but they've been out there, and people have been talking about them, and it just kind of got out premature. Okay. All right. So let's go to the IDR enforcement process. And I know that there's a lot that we're going to talk about today, so I want to keep my comments short here, and then I guess if there's any questions. I think a couple of things. Where it does work well is when the taxpayer and the team are talking to each other, the right people are there who understand what the issues are. We in the IRS are putting forward why we're concerned with that particular issue, that particular tax return, talking about what information is available to substantiate that issue, and then determining how long it will take. I think that's where this process goes very well. The challenges that I have heard about and that I have seen is when, and most likely this is going to occur in a very large taxpayer examination where maybe there's multiple issues, the taxpayer has constraints, and so what's happening is the team, the IRS team and the taxpayer are talking a lot about what's needed. They're spending a lot of time in the draft stage, and so months go by, and then when they get to the actual IDR being issued, there's more months tacked on there, and so what we're doing is we're prolonging the examination process, which is not a good thing for the IRS, and it's not a good thing for the taxpayer. And where I really, I get bothered by it is when the clock is ticking, and what someone might have thought was an 18-month examination process, or in a closely held, under a year, becomes a lot longer than that, and nobody can understand why that is. And it is because of all of these extra months and time that people are taking to come up with whatever it is they need to substantiate the issue. And that's what I see as the problem, and I think the problem is on both sides. I think to the extent the agent is doing that, I think they're going to run into problems. We have statute of limitations. They're there for a reason. But I think taxpayers who want to maybe take that approach, we're not going to be out until we're done. And I guess, how that plays out, we'll see. But that's the one thing that I see that just is not working in this process. We put this tool in place so that we could get to the, what information is needed, and then get to an examination process that was efficient and effective. So I don't know if anybody has any questions or...
Well, I think one of the problems that we've been seeing is that perhaps training or a guidance might be needed for the teams in instances where it doesn't seem like they have a clear answer to proceed with the summons enforcement action, or if they should continue to work with the taxpayer. An example would be where the taxpayer has searched its books and records to locate a record that maybe was maintained overseas and they weren't able to locate it. They come back to the exam team and the exam team says, you haven't been able to give this to me, so I'm going to start with the summons enforcement process. And I think in that instance, they said, our hands are tied because it doesn't say that we can stop. You didn't give us anything. And the point was, well, there's nothing to give. And ultimately, through elevation, it can be resolved. But it is difficult to want to elevate every single issue up the chain.
Yeah, well, I do think, and thank you for bringing that up, I do think elevation is necessary. There are taxpayers who don't like to elevate. They feel it somewhat diminishes the relationship with the exam team. I'm not sure that I agree with that. I think, to the extent that somebody's asking for something and the taxpayer can't get it or it doesn't exist, then there has to be a conversation about what does exist to substantiate the issue versus trying to put forward something for summons that does not even exist. I mean, that sounds like a fruitless effort to me. So, I get your point that not everything should be elevated. I mean, people are busy, but I don't think council would want to support the enforcement of a summons for something that doesn't exist. So I think that's important to have a conversation about, you're asking for this, can we give you something else to satisfy you? And I think sometimes agents don't quite like that because they think maybe someone has that document and they just don't want to give it to you and they want to give you something else. I think that's the conversation that needs to happen as to, you're asking about this particular issue. We want to, help get information, but it's a matter of not having this and maybe something else. So other than that, can we move to the, the examination process. So I've been, we pushed out the new publication 5125 in May of this year, and so I think the one area that is causing some problems, I think, for both taxpayers and the IRS is the acknowledgement of facts, IDR, that is pushed out. And so this was raised to me back in early summer. I was at a roundtable with the AICPA, and I don't know if it wasn't explained to me that well or I really didn't understand. And so I started asking around, and so now I get what the issue is. And so before I get into it a little bit, I'll have you know that we're working on maybe fixing some of this and having communication with the externals on how best to fix it. We're not just going to make a change and then you say, well, that doesn't work either. So I've instructed a team who was already together talking about this to make sure that we get with the external stakeholders to make sure it's going to work. So I think the acknowledgement of facts IDR was put in place as a result of the Appeals Judicial Approach and Culture, AJAC. I think for those issues that are going to go unagreed, they wanted some type of substantiation to show what had the taxpayer provided in facts. So when the case got over to appeals, the taxpayer was not raising new facts. Or if they were, exam had an opportunity to weigh in. And I think what's happening is the field is confused as to, I don't know if it's just confused. I think what's happening is they're putting down the facts as they're given, but from what I'm hearing, the taxpayer doesn't quite understand where the IRS might be going with the issue. So it's very hard for them to acknowledge those facts if they don't understand exactly what the IRS's position is, what the analysis of those facts are. And so that's what I'm hearing.
Yeah, Rosemary, we had discussed this pretty extensively, I think, during one of our prep calls, and one of the things that we're seeing on the representative side is you'll get a statement of facts, and as you start to work your way through them, you don't have a full sense of what the IRS's theory of the case is. So it's a little hard to evaluate whether or not all the facts that have been presented to you are relevant, if there are relevant facts that are missing. And then I think, too, there's also, and this is almost a Steve Colbert type of question, there's almost a discussion about what's a fact. Some of the facts are very easy, you know, the taxpayer's name and address, and then other facts sort of almost look more like a characterization of facts. I think that perhaps there was an expectation on the part of the private bar that this would look a little more like the tax court stipulation process. And there are differences between this process and that process, and perhaps those are appropriate, but it's kind of a learning curve for all of us, I think, to work through those differences.
And then as you think about the differences, you struggle with, do I just address the facts that I agree with and say, these are the ones that I agree with, the rest are characterizations, or the rest are more of a legal argument that you're embedding in your facts, and then how do you effectively and in that collaborative, communicative way that is expected, provide that information to the exam team. And so that's one of the things that I know that we're struggling with and my clients are struggling with is what's the right type of response?
You know, it's interesting to me because I can understand why we put it out before we were going to issue the notice of proposed adjustment, because I think that we're trying to say, do we have all the facts before we spend this time doing the notice of proposed adjustment? NOPA. But I think that the NOPA, if you had it in front of you, you should have the analysis right in the government's position. So I'm questioning whether or not the way we even have it organized is the appropriate way. I think what we're trying to do is maybe eliminate a step if in fact we have an agreed case. There's no need for this acknowledgement of facts. So maybe somebody thought we would do that, but you can't do that without an analysis of the facts and what the government's position is. And I think where the campaigns will be helpful is that when we push out a campaign, we're going to say why we're in this space and what we expect to achieve. So I think people are already going to know what the government's position is on an issue. Of course, if we're in a place where the regulations are unclear, the law is unclear, then that makes it a little bit more difficult. But I think the campaigns will help where at least taxpayers will know why we're here, right? And so you'll kind of know what the government's arguments are. But we do have a team who's already working on something, and so I saw it and I went back and said we at a minimum need to speak with the external stakeholders, and then whether or not it's done before the notice of proposed adjustment or with the notice of proposed adjustment, I think we'll talk about that. But I'm hearing everybody's concern.
And it's really encouraging to hear that you're working on a process to address some of these challenges that have come to light. Do you have suggestions on ways for those of us who are external stakeholders to get involved? Would it be appropriate for the ABA, for example, to send a comment letter?
Yeah, so I have the same issue with, not that I want to talk about the compliance assurance program, but with CAP, we're going to get to a point pretty quickly in which we're going to want to talk with external stakeholders. And so whether it's with TEI and ABA, I don't know that I need a formal comment letter, but I want the right representation at the table. And so I'll make sure that I reach out to a variety of folks to make sure we have that representation. I take the point.
Well, the Admin Practice
much
Committee would
appreciated.
really like to help you with that. So.
Okay.
All right. Thanks very much, Rosemary. I think we're going to turn it over to Maggie to give us an update on developments and appeals.
Okay, thanks. I'm having some technical difficulties, but hopefully you all can hear me. Not to be outdone by LB and I do want to mention that appeals realigned this month, the beginning of the month. It's not a significant difference, I don't think, that for most of you, but due to attrition and trying to right size our spans of control, we now have 4 functions under the chief and deputy. And a few changes. ATC operations, which handles most of the largest cases, is now under the examination function. John Cardone is the executive director of the examination function, and Reinhard Schmuck continues to direct ATC operations. International, my operation remains in what's called specialized exam referral and programs, and has a lot of the different specialties, estate and gift, TEGE, art appraisal, things of that nature. There's a third area collection. All of the collection now is under Scott Reicher, and then there's a 4th headquarters function. So just a quick highlight there on our realignment that occurred at the beginning of this month. And I wanted to just jump into a couple of the policy clarifications. A lot of it ties into Rosemary's last topic, which was really about trying to bolster appeals independence, ensure that appeals is not functioning as the fact finder, the first finder of fact, but rather engaged in its role as a dispute resolution area. So as many of you know, a couple years ago we began what was referred to as AJAC, the judicial culture approach, and really this year that's been extended, expanded into the docketed case area. So cases docketed in tax court. If you could switch to the next slide. The docketed exam assistance really is just furthering a lot of the work that we did in AJAC to make sure that with the docketed cases, the appeals officers have a mechanism where they can go to exam and get exams position on new facts, new arguments. Obviously, we can't release jurisdiction on a docketed case. So the new docketed exam assistance procedures, they really just provide a formal procedure for appeals officers. In the past, it was a little bit, difficult because some local offices had agreements with compliance, some didn't. So this provides all of the appeals officers a clear mechanism to make certain that they can get their information to the right person in compliance. And then also counsel is in the loop and is aware, given obviously there's unique situations with docketed cases with calendar calls. And so this is just really extending what we've already been doing in the non-docketed area and making sure that we're taking the same approach in the docketed area. So a couple of things really to highlight. Obviously, as I mentioned, appeals would retain jurisdiction of the case. We're not going to be releasing jurisdiction of the case. And also, whatever assistance that compliance provides, assistance sort of in quotes, it's really, we're trying to get compliance's position. As Rosemary said, we want to make certain that we have both parties' position clearly stated. If it's new facts, if it's new arguments, that the taxpayer will obviously also receive that information so that they can, provide their own position or rebut that position. Okay, and then sort of an extension of, I don't know if it's an extension, but it ties in, this year Revenue Procedure 2016-22 was issued. It is an update to 8724, and again, it's really in the docketed case arena, and it addresses procedures for an interaction between counsel and appeals. And it really makes clear that once counsel hands a case off to appeals, it is exclusively in appeals jurisdiction to settle that case. Previously there was some question in different parts of the country in terms of how that was happening in practice, but this makes it very clear. Once a case is released to appeals jurisdiction, appeals has authority to settle that case, and then it provides for communication in circumstances in which counsel may not release jurisdiction to appeals and may retain that case.
And I was wondering if we could dig into that just a little bit more, Maggie. The revenue procedure says that in certain situations, counsel won't refer a case to appeals, and those situations that are identified are cases that are designated for litigation, which I think is fairly obvious, but then also cases or issues that aren't designated for litigation, but where referral isn't in the interest of sound tax administration. I have a fairly active imagination, and I can imagine all sorts of, particularly as Halloween is coming up, nightmare scenarios where something might not get referred to appeals because it's not in the interest of sound tax administration. So I was hoping you could provide a little more guidance on that and perhaps put my mind at ease.
Well, I mean, truthfully, we would have to get more guidance from counsel along those lines. I mean, I will certainly say, already in the non-docketed case area, there are times when we have procedures in our IRM where we have to coordinate with counsel and the Department of Justice if they're related cases, related years, related taxpayers. And so that's a circumstance where I could see, if a case is stat noticed and there's related years, related taxpayers already in, tax court or with DOJ, that's a situation where I could certainly see that a case may not be designated for litigation, but would not be forwarded on to appeals. And I don't know if there's any other comments that anyone in the Hannah would have?
I guess with things that, as a practitioner, I would be wondering is, when that decision is being made, is the taxpayer included in that? Is there any appeal of the decision? And so I'm hopeful that there'll be more guidance as to how that might look so that people like Alexandra's nightmares can go away.
Well, I mean, I certainly can say, under the terms of the revenue procedure, one of the things that appeals, I think, was, and council were quite clear on, is that this, this decision will be communicated to the taxpayer upfront, which was something I think that was not necessarily always happening in the past. So I think that's something that this revenue procedure makes quite clear. With respect to the process and council's decision-making, I really can't speak to that.
I think in some cases, certainly council will be talking to the business unit. I think in instances where appeals does not have the full picture might be an example, and they do give an example in the Rev Proc. This is council has the approval here, division, council, or higher, and then it is communicated to the taxpayer by council. So it's outside of exams jurisdiction.
So I think we've got an audience question.
Yeah, just a comment. This is not new. Back in the olden days, obviously township office, you could keep a case back if you felt that it was, we didn't use the language like better means of tax administration. I mean, it could be for lots of reasons, including council might have had involvement in development and felt that they wanted to keep the issue and move it forward without releasing it to appeal. So
Right, I think I think that it was never very clear. There wasn't a lot of clarity around the communication. There were different practices, I think, across the country with different council offices. And I think, both appeals council, recognize that rather than having these ad hoc decisions, that really there need to be clear communication and decision-making up front, and, make certain that the taxpayer was made aware. And, this comes up, and to sort of segue to the offshore context, which we're going to talk about later, this comes up, for us when there's different parts of an offshore case. And, if we receive, for example, an FBAR penalty or foreign trust penalty, and we're looking for the 1040 piece, the fraud penalty that might be docketed, trying to make sure we have the whole case together. And, that came up a few times in the past, and maybe a council office was holding on to it, and we weren't certain what was going on. So I think this is to make certain everybody knows on the front end what's going to be happening with the case.
So when I read this language for the first time, it just struck me as essentially a statement that the rest of the provision wasn't an absolute rule, that if something doesn't make sense, we left room to come up with a different result. That's the way I took it.
I know we're on a tight time frame. Do you want to
Sure. Let's
skip
move on
ahead
to some of the other.
Case transfer and conferencing?
Yeah, we can.
Okay, this is another recent change. We've been very busy in appeals. This was just clarification, really about, some recently we had been putting out some letters, really in I think the context of AJAC. Some of the letters were changed, and they seemed to express a preference for or suggest to representatives and taxpayers that they needed to request a face-to-face or in-person conference up front. And so these new procedures really clarify that most of our cases, most of the appeals cases are actually resolved over the phone, and that there's not necessarily an advantage to being in a face-to-face context. There's certain criteria that I'll mention quickly that the appeals team managers will take into consideration as to whether or not a face-to-face conference should take place. Obviously, if there's, substantial books and records that need to be referenced or reviewed, that would be a circumstance. Any sort of alternative dispute resolution, fast-track settlement, post-appeals mediation, those types of scenarios. If it's important to judge the credibility of an individual or oral testimony, I think of, for example, like maybe the innocent spouse type context, that would be a good example. Also, if there's numerous participants, maybe a lot of specialists. Obviously, in the international area, we frequently deal with economists or, appraisers or engineers. So those are the types of criteria, and they're going to be in the appeals IRM section. But I don't anticipate a big change with respect to, the ATCL cases or the international cases in terms of how they've been handled. As I said, we have handled many, many cases over the phone, but this is really trying to put some criteria in place so that, folks don't think that they need to request a face-to-face conference. And then, we've had many circumstances where people have requested a face-to-face conference and then, to get a case maybe transferred out of the campus or to a different location, then they don't actually show up for the face-to-face conference. So obviously we have resource considerations that we have to take into account. So we want to make sure that there's appropriate criteria, we're getting the right case to the right people, and we're using a face-to-face or an in-person conference when it's really necessary.
Thanks very much. Before we move on to discussion of FBARs, I want to give both you and Rosemary an opportunity for to discuss with us any anecdotal evidence you have about the effects that the changes are having so far. I think one of the things that we've been talking about is what the changes are motivated to do, in part, is to get you to make your case at exam and not to bring up facts for the first time at appeals. And so I'm wondering if it is developing as expected, how often cases are getting returned from appeals to exam.
I don't have any specific numbers. I have not personally seen or experienced a significant uptick or change in cases or information going back, compared to, I guess, my experience in past years. I do think, everyone, certainly representatives and taxpayers, are more conscious and aware now. I think that, that they need to come forward. And when we have, again, the offshore area is a good example. If we have a new representative or a new practitioner coming in, which sometimes happens when someone comes to appeals, they'll hire a new representative. Maybe they weren't happy with, what took place or transpired in compliance. That's a situation where I think people do have to be conscious and aware that, if you have new representation, they're going to be trying to present new facts or new arguments, that's a situation where appeals is either going to be returning the case to compliance or, in the docketed situation, be engaging compliance to make sure that we have, their position and that we are really looking at both sides. And that's what, both compliance and appeals want, is to make sure that appeals is really, again, acting as a, dispute resolution part of the IRS, and not trying to, we really don't want to be perceived as an extension of compliance, of trying to ferret out facts, trying to be developing exams position for them. It's not our role, and we try very hard to maintain that independence. So.
And I don't have anything to add to that. I think it's good, though, for us to probably go back and see, if we have any significant numbers there. I think if we did, Maggie probably would know that in terms of it being a significant number. So I don't think so.
Well, great. Thank you both. I think at this point we'll move on to FBAR developments with Jennifer and John.
All right, I thought we'd start with the couple actual developments in the rules. First of all, many of you may already know the due date for FBARs changed from June 30th to April 15th to coincide with the tax return filing, and that's effective for this year's FBARs that were recently filed. Secondly, about a year ago, Congress mandated that all the agencies index penalty amounts for inflation, and a couple of months ago Treasury came out with an interim final rule that implemented that for FBAR penalties. So the numbers have bumped up from 10,000 to 12,459 on non-willful penalties, and from 100,000 to 124,000 for willful penalties. Next. Okay, we had some guidance come out in 2015, in May 2015, to try to get a little more uniformity in the outcomes of FBAR cases, because it's a challenge with them being examined all over the country and not a lot of experience with it. So this was worked on for quite some time, came out in May. It was the substantive parts were incorporated into the manual in November, but the procedural parts have not yet been incorporated into the procedural FBAR manual. So the guidance memo that came out in May of 2015 still has some relevance, and the key points that I wanted to note are that the agents are supposed to be consulting with FBAR coordinators, regardless of what they think the penalty should be. But they no longer have to go to counsel's coordinators unless they are asserting a willful penalty. So for the non-willful stuff, it's all being handled by the compliance side coordinators. Now, these next two slides address the substantive, I call them default rules for willful and non-willful FBAR penalties. The general approach for willful is going to be to determine one 50% willful penalty on the highest balance and spread that over the open years where the service believes willfulness is present. So it could all go on 1 year, it could go on multiple years. But that's the general default rule. As always, this is a judgment matter for the agent and the manager and the coordinator, so they can depart upward, they can depart downward. And the mitigation rules are written into the manual so that if, depending on where the case falls out in dollar amounts, if you've been cooperative and there aren't some other factors that would kick you out of mitigation, it's possible to apply those rules to mitigate the numbers downward. And the next slide discusses non-willful, and there the default is going to be one non-willful penalty of $10,000 for each open year. And again, the examiners have discretion to apply the mitigation guidelines or to use their common sense to come up with a different number. Yes?
10,000, is that 10,000, is that also reflected with your inflation adjustment?
These slides don't take that into account because the inflation adjustments don't kick in until I think it's FBAR's filed or due after August 1 of 2016. So for today, it's still 10,000 and 100,000.
The IRS,
Yeah.
the number of the IRM will be adjusted, or will reflect the adjustment.
I can't guarantee the IRM is going to get adjusted, but eventually it will. But this is going to change every year now, so we'll probably change the manual in some way to reflect that the number will be changing without having a flat number in it, would be my guess.
And can I just make a quick plug? Appeals worked with counsel and compliance a bit on this memorandum, and we gave them quite a bit of feedback that, you know, taxpayers for a period of time were not receiving a clear written description of what the penalty was or why. And so, you know, another piece of this guidance is to, you know, that it instructs the revenue agents, you know, what should be in the FBAR file, what they should be providing to taxpayers. So, you know, if you have a taxpayer with an FBAR penalty, they really should be getting a summary memorandum explaining to them what penalties being asserted, why the amounts are being asserted. And early on, we had some challenges with that, but I think this guidance has really, you know, taken us all a long way.
Yeah, we had a case called Moore where the judge chastised the government for being arbitrary and capricious in not informing the taxpayer of the reasons. He ultimately agreed with the service when the reasons were explained, but it was very unfortunate the taxpayer never got an explanation until they got to court.
Right, and so, yeah, this has helped quite a bit, and we've seen in appeals.
Rich?
Seems like the intent of the mitigation, certainly the non-willful, was to bring it down to, you know, one $10,000 penalty rather than a per account penalty in the average case. But was that also an intent where there's a husband and wife situation that you don't have two penalties?
It's split, right?
Yeah, I would expect it would be split.
It is actually, it's split based on the ownership of the
Well,
accounts.
that's true. There's a
Yeah.
provision in there for any joint ownership,
Right.
not just husband and wife. For any joint ownership, it's split.
Right, the intent should be that there was one $10,000 penalty as opposed to, okay, there's husband and
Right.
wife, so there's three accounts, there's three $5,000.
That is what we see. Usually we'll see the revenue agent will split it 5,000 each, you know, assert a $5,000 penalty against each of them, you know,
So you turn
right.
the penalty into a $15,000 penalty.
Well, no, like if it's a husband and wife, two joint owners of that account, then,
3 accounts.
oh, 3 accounts?
Yeah, there's three accounts.
The default rule is one $10,000
Right.
penalty per year.
Right.
So if there are 4 years, it's going to be 40,000, but it's split between the husband and wife.
Right, so a total of 40,000 between the two of them, right?
So in the interest of time, I want to move on to our case study about how an offshore case would develop under the new procedures, but I want to make a little public service announcement for those of you who do offshore cases. I think we're all sort of accustomed to dealing with folks at the IRS, but offshore cases, I think, add an additional wrinkle in that you may be dealing with personnel from FinCEN and also folks from the Bureau of Fiscal Service when you're talking about collection matters. And John, I don't know if you could take a minute or so and kind of explain to us what the different roles are.
Sure. The rules are made by FinCEN. This is their issue. It's the enforcement, the compliance piece that has been delegated to IRS. So we do the examinations, but if you have an issue with the way the rules work, your issue needs to go to FinCEN to discuss that. Bureau of Fiscal Services comes in after we make an assessment. Our Detroit office refers the assessment on the FinCEN system over to Bureau of Fiscal Services, which does all of the general collection for non-tax debts. And they do that through their Treasury offset program. So you're going to start seeing your clients' refunds getting taken to pay the FBAR. If they're a government contractor, those payments can be offset. Whatever payments the government owes the taxpayer are going to be offset against the debt. And when we get pushing up maybe 6 months from the expiration of the 2-year statute of limitations to get a judgment, the case will get kicked back to Detroit, referred to my headquarters office. We farm them out to the field to write referral letters to the Justice Department, and then the Justice Department files for a suit. But the offset potential could go on forever. There's no statute of limitations on that.
And just a quick plug as well, you know, if you have taxpayers that are working with compliance and compliance requests, you know, a consent to extend the statute, I would recommend that they, you know, extend the statute, because if the penalty is assessed and it comes to appeals and it's over $100,000, because it's Title 31, it's not Title 26, it's considered a claim of the U.S. government. And so if it's assessed when it comes to appeals and it's over $100,000, appeals cannot compromise that penalty without Department of Justice approval. So FBAR penalties can come to appeals either pre-assessment or post-assessment. And if it's pre-assessment, obviously, then we have, you know, the authority to potentially compromise if there's hazards or what have you. But if it's post-assessment and the penalty exceeds $100,000, then we would have to get approval and consent of the Department of Justice.
That's a helpful reminder. And now I'm going to apologize to Jennifer and John that they have 5 minutes to cover our remaining material.
Well, I think we put together a couple of very basic fact patterns for you all, and I think because of time, we should just cut to the chase. Yeah. We have 3 very general basic fact patterns, and I'm just going to turn to John and say, okay,
Does any of this matter?
does the fact that we have all different facts really make any difference when it comes to how you guys are going to approach a case in any one of these situations?
I think from a process standpoint, the facts are kind of irrelevant. You need to approach the case the same regardless of whether you've got a strong or a weak case. I would develop the facts on your side as best you can, get them presented to the agent as soon as you can. If you're having difficulty communicating with the agent, my advice is always to put your position in writing, because then you're expressing your argument in your own words and you're not relying on the agent to paraphrase. So put it in writing, and then that will be in the file if it goes to appeals. And you can do the same thing with the protest. But I think the important thing is to get the facts developed as quickly as possible. The agent's always going to want to interview, almost always going to want to interview the taxpayer in these cases. If there is a preparer, they should be interviewing the preparer in every case. So you need to be prepared for that.
And even backing up to a stage before the actual development occurs, as far as the way that you are looking at potential cases to select or taxpayers that you'd like to look at, is there any difference in the way the IRS may approach these different scenarios, or do you see different identification approaches occurring here?
Well, the FBAR cases are pretty much developed along with the Title 26 cases. Whatever source of information we have, whether it's a whistleblower or summons on a bank, we develop the FBAR case along with the tax case, and they're generally worked together with something called a related statute memo so that we can use the tax information to build the FBAR case.
think we're probably good.
Yeah, so I think there are a couple of key takeaways that we wanted to highlight for all of you. And I think this last slide, if there's only one piece of material that you retain from today, is probably the key information. But to familiarize yourself with existing IRS training materials, provide all your facts and your documentation to exam during the audit, elevate issues within the exam hierarchy if you reach an impasse, and of course, don't wait until appeals to introduce new experts, counsel, and facts. If any of my panelists would like an opportunity to say a final word or two?
I think just what's said there, as much as possible, if we could have, the information provided to compliance up front so that we don't have to return a case or, delay resolution of the case by bringing, compliance into the picture of the docketed case, I think everyone wins in that situation. So, provide information up front, work with compliance, and there are a lot of different, then opportunities available to try to seek resolution.
And I would say what we really strive for is to have the most efficient examination process. So to the extent that taxpayers and teams work together in trying to identify what information is needed to resolve those issues and get at, and be transparent as much as, if you find that your agent or your team is not transparent, I think you should talk about that earlier versus waiting to see if that's going to get better. And also to the extent on the taxpayer's side, it does work a lot better if you come to the table prepared with the right people to respond to the questions that we have.
Well, thank you all very much.